Hello, I'm Alison Dundes Renteln. I'm a professor of political science, anthropology, law, and public policy at the University of Southern California. I'm delighted to be here to be the moderator for this panel, Judges as Gatekeepers, Courts, and Scientific Evidence. It's exhilarating to be here with so many innovative jurists. And I'll begin by introducing our three speakers, and then I'll help with the questions afterwards. Our first speaker will be Judge Nancy Gertner, who was a United States District Court judge. She's retired. She served 1994 to 2011. Prior to that, she was a civil rights and criminal defense attorney in Massachusetts. And after she decided to leave the federal bench, she joined Harvard Law School. She is the managing director of the Center for Law, Brain, and Behavior at Mass General Hospital and Harvard Medical School. She is very widely published in many areas: sentencing, discrimination, forensic evidence, women's rights, the jury system, and the Supreme Court. She has received numerous awards, too many for me probably to go through now, but including from the National Association of Women Lawyers, American Bar Association, many other distinguished awards. And she has been named one of the most influential lawyers of the past 25 years. She's been featured in many major papers and legal publications, and she's the author of an autobiography in defense of women, Memoirs of an Unrepentant Advocate, and she co-authored The Law of Juries that was recently updated in 2010. She's also the author of a volume of dissenting and majority opinions of Justice Ginsburg, and is currently writing her second memoir. She has served in various policy-making roles. She's been senior advisor on the Presidential Council of Advisors on Science and Technology, Forensic Science and Criminal Courts, and she's a member of the MacArthur Neuroscience Network. And she's written, as judge, has written numerous decisions on all the issues of related forensic evidence that we're going to hear about. She's one of the leading authorities in the world on the law, science, and forensic evidence. So she's an extraordinary scholar, and we're very lucky to have a chance to hear her. So I'm going to move on, but that's really not doing her justice. Dr. Tess Neal, our second speaker, is an associate professor and dean's professor of psychology at Iowa State University. Prior to that, she was tenured at Arizona State University, where she was the founding director of the Future of Forensic Sciences Initiative, which then turned into the New School of Interdisciplinary Forensics. She also was a co-founder of the ASU Law and Behavioral Science Group and the principal investigator of the Clinical and Legal Judgment Lab. She is a licensed clinical psychologist, and in this role has assessed, diagnosed, and treated mental and behavioral disorders, and her work as a forensic psychologist has led her to have a great experience bringing psychology into the illegal context. Her work has been funded by multiple grants from the National Science Foundation, and she's published more than 40 scientific papers. And she's the incoming editor-in-chief. In January, will be the editor-in-chief of Psychology, Public Policy, and Law. Congratulations. And she's a fellow of numerous learned societies and professional associations. The Association for Psychological Science and the American Psychological Association, and was recently a Fulbright Scholar in Australia just last year, so very distinguished. And then our third speaker, equally distinguished, is the current director of the Research Division of the Federal Judiciary Center, and she has been on the staff of the center since 1989. Her areas of expertise include research methods for the study of legal systems, civil case management, bankruptcy law and procedure, judicial workload measurement, court performance standards and assessment, judicial performance feedback, workplace environment surveys, courtroom technology and digital evidence, and access to justice and unrepresented litigants, things totally unrelated to our subject today. She's helped judiciaries around the world to undertake empirical work to assess the quality of their court administration. She's a fellow of the American Bar Foundation and the American College of Bankruptcy. She was previously on the faculty of Johns Hopkins University of North Carolina. No, I've got it wrong. the University of Maryland, but she has degrees from North Carolina and Johns Hopkins. No, you're on the faculty of Columbia. I'm sorry. Please correct me, and if I've left anything out that's crucial, you all are so accomplished, it's difficult for me to know what to pick out here. So I did want to say that this is exciting to think about what could be solutions to some of the issues that we're exploring. And I'm hoping that in the few minutes we'll have after your presentations, we can talk about what you see as possible solutions to these issues of forensic evidence. Chancellor Mnuchin's brilliant introduction in that she expressed some skepticism, at least during Q&A, about science courts or expert juries. But do we need a better certification system of experts? And what about peer review? Is peer review, can that be a form of censorship? And what about these tests that we're talking about? Do they apply to things like anthropology where you can't have replication? And finally, we seem to be mostly talking about American law, and I think some of you will be putting this into a comparative perspective. What can we learn from the civil law tradition? So without further ado, please welcome our wonderful speakers, and they're going to take the lectern now.
It's wonderful to be here, but I think I have nothing to say. I think Mnuchin said it all. And because this has been a continuing conversation between me and some member of my, of members of this, people in the audience, people who are part of this program, I can hear my thoughts evolve and things that I've said being said by others. So I've lost all track of what I believe in and what they believe in, but I will try. In fact, this presentation derives from a conference that Jennifer put on at UCLA, which was about how come the National Academy report is not being addressed by judges at all. It's not even mentioned. The conference was, how did that happen? This incredible, important report that said, famously, 2009, courts have been utterly ineffective in assessing the research basis for forensic science. And so the conference was about how is that why did that happen? And I'll talk about that in a second. And then only 7 years later, 2016, as Jennifer mentioned, the PCAST report came out and was much more directive. It was not just saying courts have been utterly ineffective. It was, there is stuff out there that is clearly junk, and notably talked about bite mark testimony. Notwithstanding PCAST, bite mark testimony was introduced in various places around the country. Much less, certainly discredited, but nevertheless the notion that a judge anywhere would have said, I know that these scientists said this, but who cares? I'm going to let it in. And that led me to want to look further into why it is that judges are not looking in any depth at the forensic evidence. And what I found, I want to make 4 points. And by the way, I have this on a PowerPoint, but one of the disadvantages of PowerPoint, which we see when I listen to Jennifer's presentation, is you get stuck in it, right? You can't, it binds you to the 5 points you were going to make, and the advantage of just talking to you is not being bound by that. But there are certain principles that I think reflect both what Jennifer said and I think which are things that are the case. One, and I'm looking mostly at criminal, actually. So first is the problem of precedent. How could precedent have anything to do with science? And the answer is the fact that certain evidence has been admitted without objection for decades creates a disincentive to challenge it. Ironically, new science, DNA, was subject to rather searching review when it was first introduced into criminal cases, but not so with ballistics and fingerprinting and bite marks and et cetera. So there's a problem of precedent. The judge behind me has allowed it in. Everybody, the court has affirmed him multiple times. Why should I be the one to stick my neck out? That ties into the problem of advocacy. If the lawyers will look at this as having been admitted over and over again, and then there's no incentive for them to challenge it. There's no incentive. Of all the things that a lawyer has to do in a criminal case, this is the least likely they're going to do it, and so they don't. And if the lawyers don't tee up the issue, and I have had numbers of experience in my career as a judge, if the lawyers don't tee up the issue, it is admitted without objection. And then there's a problem of trial courts. There is an enormous difference between forensic evidence in trial courts, criminal courts, and forensic evidence or any kind of expert evidence in a civil setting. And I will get to that in a minute. There's an enormous difference into the circumstances of the challenge, not just the kinds of resources, but the kind of time devoted to it. And again, if the lawyers don't tee up the issue, because why bother if it's been admitted for decades? Obviously, a trial judge counting on the pedigree of the evidence won't address it either. And then something that Jennifer mentioned, which I really think that people should talk about more, is a problem of appellate review. We train trial judges. We talk about the admissibility of the evidence in the first instance. We do not train appellate judges. And although this is not great for a presentation, I'll get to my last point at the beginning. Until we change the abuse of discretion standard and until courts of appeals begin reversing admissibility decisions, there will be no incentive for anyone to challenge some of the more problematic, particularly forensic evidence. So as I said, it's a vicious cycle, problem of precedent, problem of advocacy, problem of trial courts, and a problem of appellate review. Let me get to the problem of advocacy for a moment. A lawyer makes a calculation. I have only limited resources, and I'd rather do it on something that I think will win. And the perfect example of this, which is one of the most troubling cases I tried as a judge, was an arson case. Nothing was litigated in advance. Nothing, zero. I heard nothing about the case. There were no motions, no in limine, nothing. I get on the bench. The first witness was a dog, Billy the dog. It wasn't actually a dog, it was a dog handler. The dog handler gets up and testifies that Billy went to a certain part of where the fire had taken place and wagged his tail in a way that I knew, the speaker said, to be a sign. I literally dropped my pen. There's moments when being judge-like is actually very difficult. It was about 9:45. The case had begun at about 9:15. I turned to the jury. I stood up and I said, I think the jury should take a break at this point. And the jury goes into the jury room. I turned to the lawyer and say, you're going to challenge this? Now, you understand I did not have to say that. He had not challenged it in advance, and therefore there was no reason for me to say it. And he says, no, Judge, we're good. We're good. Now, at that point, I don't know whether what he's doing is a calculation. There's something I don't know. I don't know much about the case, whether this is a strategic decision, and I let the testimony go on. At that point, the witness talks about how the dog snorted in a way that he understood. I was losing complete patience, but holding on to my judicial demeanor with all my heart. Again, I let the jury take another break, turn to the lawyers and say, are you going to challenge this? And the lawyer said no. This jury must have gone to the bathroom 70 times by the time noon came about. But all the testimony came in. The defendant was convicted. There was not a motion to set aside the verdict. And I, because there had been no pretrial of this case, didn't have the tools to even dig deeply into it. To make a long story short, many years later, I get a habeas petition. We finally plumbed the depths of what arson science had been at the time, the issues that the lawyer missed, and I grant habeas relief to the defendant. But there's many things about that case that are significant. There were no dog cases on the criminal side. All of the cases challenging dog testimony were on the civil side, which raised one of the points that Jennifer was raising, which is there is an enormous difference between the civil and the criminal side in terms of resources, and not just resources, but as I'll get to in a moment, in terms of the setting in which the litigation takes place. Civil cases proceed slowly. There is an anticipation of pretrial motions. Criminal cases, even in federal court, proceed quickly. Motions, if you file motions in a regime which is 97% plead, you could wind up with a judge holding you essentially, you'll lose your ability to get substantial assistance points, which are essentially lesser sentence for pleas, if you challenge. In a busy court, in a busy urban court, where decisions are made with cases one after another with virtually no time, then there's not the time for the kind of contemplation that you see on the civil side. So there's a problem of, as I said, a problem of advocacy. There is a problem of trial courts. You're talking about busy trial courts. There's a problem of appellate review. The standard is abuse of discretion. I have a way of describing abuse of discretion. I've done this speech before, so there's a funny way of describing abuse of discretion. The Commonwealth of Massachusetts described abuse of discretion as follows. No conscientious judge, acting intelligently, could honestly have taken the view expressed by the trial judge. Let me unpack that. No conscientious judge must be a laggard, acting intelligently, an idiot, could honestly have taken the view expressed by the trial judge and dishonest. Now, of course, they've tinkered with this standard, but as long as there's an abuse of discretion standard, then the busy trial judge knows that he or she can take his chances or her chances and let the evidence in. And particularly if it's pedigree evidence, that is to say, evidence that has been admitted over time, you take your chances, the odds are you'll be affirmed. And then it's the beginning of a vicious cycle. You take your chances, you're affirmed. It's affirmed on an abuse of discretion standard, which actually only means there's a range of discretion and you're within it. It doesn't mean you were right. But typically those decisions are then used to justify allowing the evidence to come in case after case. So there's a fundamental problem of the appellate standard. There's a problem then up the line, which is post-conviction relief is very limited. We hear about innocence cases, but in fact, habeas review is very limited, so you won't get review at that end. The limited experience of appellate judges often makes it very difficult for them to even envision error, and the Supreme Court rarely grants cert in these cases. Let me end with one story to give you an example of exactly, again, the criminal side, the problem of advocacy, the problem of appellate review, the problem of resources. This was a case that came down as I was on my way to the conference to talk about the NAS report. And I get a note from my staff that I have just been affirmed in a fingerprinting case for not having held a hearing. Affirmed for not having held a hearing. I look at the name of the case and I said, I don't know what you're talking about. I held a hearing. And here's the story. A lawyer comes to me literally in the middle of jury selection with a one-page motion, and he says, I'm going to challenge the fingerprints in this case. And I had every right to say, too late, not going to look at it. But I don't say that because I had a background along these lines, and I said fingerprints can be challenged. Jury is selected, the jury is waiting outside. I say, okay, put on your evidence. The government's witnesses are there to talk about fingerprint evidence. The lawyer looks at me and says, quote, I have nothing, Judge. I said, what do you mean you have nothing? He says, I have nothing. I said, I'm giving you a hearing. He says, I have nothing. And then he said, really an understatement, you give me too much credit. At that point, there was nothing I could do. I said, well, you might have talked about, and I made a list of the things that I knew were issues in these cases. But I was the judge and not the litigant, and I could hardly make those findings in the absence of adversaries presenting it. The defendant is convicted, as well as likely once the fingerprint evidence came in. A case goes up on appeal. The case is United States versus Pena. The First Circuit says, affirms me for not holding a hearing. She didn't have to hold a hearing. This has been evidence that has been admitted over and over again over the years. And not only that, the First Circuit says, here are the reasons why fingerprint evidence should be admitted. Totally the opposite of anything that I said. I wrote to the court and I said, this really is not a case that should stand as precedent for anything. This case should be withdrawn. I got nowhere, and it continues to be cited. I raise that case for this reason. It says something about how automatic, how perfunctory the review is. So it's perfunctory by the advocates in criminal cases because of resources and because these are pedigree cases. It's perfunctory in a busy trial court that says, well, I'll take my chances. The odds are that it'll be allowed, that I'll be affirmed. And then it's perfunctory at the Court of Appeals. Civil cases are different because this comes up in a summary judgment context where there are many resources and where the judge has time. So I don't want to end on a depressing note, but I do want to give some suggestions which I thought would make a difference. After the experience in the dog case, Billy the dog case, I issued a procedural order that said essentially when certain kinds of evidence is about to be admitted into my court, I will hold a hearing. You don't have to make a showing to hold a hearing, I will hold a hearing. I left the bench before anyone took advantage of that. We have to train appellate lawyers and not just trial lawyers. Appellate lawyers have to be able to identify these issues. There has to be a change in the standard of review of scientific evidence. Abuse of discretion does not work if we know that we're dealing with a situation where the law has been muddied, particularly on the criminal side. Then the abuse of discretion standard allows too much wiggle room. We have to deal with the problem of changed science. There's now, the Supreme Court, I believe, has taken cert on a case involving shaken baby syndrome. So you have the situation of science with pedigree, fingerprint, shaken baby, handwriting, but now being re-examined. And if the pedigree / precedent means that the court won't re-examine it, the law will never move. There's a model for change in courts that I want to recommend. Chief Justice Gantz of the Massachusetts Supreme Judicial Court wanted to look at eyewitness identification and did it perhaps in the only way that judges would understand. He put together a working group, judges, prosecutors, cops, and scientists to talk about eyewitness identification. They issued a report. Over time, the report then was admitted into one of the Supreme Judicial Court cases, but by the time the report came out, he had created a consensus for change. And that consensus was then reflected in new eyewitness identification instructions and changes in the court. In other words, the theory of that is that it can't be that announcing something is wrong, the National Academy report, the PCAST report, is enough. There has to be sort of institutional supports for that in the court. Until we change the abuse of discretion standard, until judges are reversed for what they actually did, as opposed to, in my case, for what I didn't do, there will not be a meaningful change on the criminal side. I would love to see, and perhaps some of my colleagues on the panel will be addressing this, trying to understand what is it about judicial decision-making that is an impediment to dealing with these kinds of issues. What is it about the structure of judicial decision-making that has made it resistant to this extraordinary chorus of challenges since at least 2009. With that, I'll stop. Thank you.
I had some slides. Do you know if they're here or if okay. I figure it out. This thing. Sorry. So I'm Tess Neal. I am excited to be here, and I'm going to talk with you a little bit more, a little less abstract. I'm going to show you, oh, okay. So I'm a psychologist by training, so some of what I'm going to talk with you about today is these same issues, but from a particular lens of psychology. So I have a little bit of empirical data that I'm going to show, but then I do to the comparative issue point. So with this Fulbright scholarship, I was in Australia. They have very different, on purpose, very different evidence rules that we have here. So I went there in part to look at, could we learn something by the way Australia's approach is proceeding, that we could take back here. And also, which hasn't been discussed yet, right now the federal rules of evidence are changing here in the US. So I will talk with you a little bit about the timeline of that, and we can have a debate maybe about whether we think it's going to work in the way intended. So before I get into a little of the substance, I want to tell you about these people all have something in common that is relevant and perhaps of interest that might make some of this more concrete. There was a Netflix show several years ago called Making a Murderer with a guy named Brendan Dassey, who was a part of the show. This guy has something in common with a woman named Andrea Yates, who drowned her children in a bathtub. They have something in common with Mike Tyson, professional heavyweight boxer, and Jeffrey Dahmer, a serial murderer and cannibal convicted of those crimes. They all have something in common with Brad Pitt and Angelina Jolie, Hollywood celebrities, and Justin Bieber, a singer-songwriter, and Daryl Atkins, a man who was a capital defendant. What they had in common was that at the core of each of those cases, there was some kind of psychological question, that the issue turned on some question of psychology. So because I'm a psychologist by training, I'm interested in questions of the quality of the type of expert evidence that psychologists are bringing into court. Of all those cases that I just showed you, those people, they were all kinds of different cases. These span the gamut from criminal to civil court, all kinds of different issues. We're talking about child custody determinations, competency, eligibility for capital punishment, pretrial sentencing, risk assessments, all kinds of issues. When psychologists come into court as experts, and this is right, different type of experts will come in and try to bring in their own type of methodology. Psychologists will bring in psychological assessment evidence commonly. And there are literally tens of thousands of different types of psychological assessments that psychologists might try to bring into court as part of their expert evidence. Now, if we take a step back and think about what is Daubert, what is the purpose of Daubert, what are judges supposed to be doing? Judges are supposed to be, right, if we have that idealistic version of the educational or the idea that they're supposed to be making the decision, not this second order thing, but this first order decision themselves about the validity of each one of these types of tools that a psychologist might bring in. That's an extremely tall order, in part because there's just so much variability in what a given expert might bring into court. And this is just one discipline, right? This is an extraordinary amount of variable type of evidence that might come in. And the stakes are high, right? So I was just telling you that we're talking about people keeping custody of their kids or losing their kids. We're talking about whether somebody's going to be eligible for capital punishment, right? These are very high stakes questions. So we know that it's important that the validity of evidence like this and all types of expert evidence, that it would be subject to careful scrutiny. But we also know, as Chancellor Mnookin very eloquently laid out, this is a very, very, very hard task. So these were, she laid this out nicely this morning, but these are some of that checklist that she was mentioning. These are some of those criteria that judges are encouraged, if there is an admissibility analysis, that they're supposed to be looking for as part of the methodology of the expert, what forms the core of their evidence. So very briefly, I'm going to tell you just from this lens of psychology how this looks in practice. So we did a huge analysis of basically all the tools we could find that psychologists have brought as evidence in court. We looked at their scientific validity. Then we looked at, are the courts calibrated to the validity of that evidence? I'll give you a very clear gist analysis of what we found. First, there's clear variation in quality, that psychologists sometimes are bringing in very scientifically sound evidence, and sometimes it's totally bunk. And the courts are not calibrated at all to that variation in quality. If the paper itself is published in an open access journal, which means it's online, it's available, you can also email me, I'm happy to send it to you if you'd like. It's called Psychological Assessments in Legal Contexts, Are Courts Keeping Junk Science Out of the Courtroom? Some of the co-authors are here today and will be speaking later on. Michael Sachs is one of the co-authors here. So very quickly, what we did was trying to line up those criteria on with the actual evidence. So this is what we found of this one type of expert evidence, psychological assessment evidence. We found that if judges, we're trying to find evidence of In any given case, on average, about 90% of psychological assessment tools had been subjected to some kind of testing. That's good. Are psychological assessment tools generally accepted in their field? We looked at 364 different tools. We found no evidence. A whole group of like 40 scientists together trying to find evidence, we could find no evidence for 50% of those tools. But we're expecting courts to have to try and make these, right? That's part of the challenge of this whole thing. And then here's the variation. So when we did find evidence of general acceptance, we found that about 33% of those tools that we know psychologists bring in as evidence, 33%, we found clear evidence that they were generally accepted in that discipline. We also found 8% there was conflicting or unclear evidence, which would be challenging for a judge to have to grapple with. And for 8%, we found clear evidence that it is not accepted in that scientific community. And yet, some psychologists, are bringing it in as evidence anyway. On the question of, we kind of combined has it been peer reviewed and what's its error rate, we looked at those together basically. We found no evidence for 37% of that kind of evidence. We found 25% had generally favorable scientific properties. These are things that we would expect if there weren't an admissibility challenge, that this type of evidence might be allowed in. Mixed evidence for 23% and 15% generally unfavorable scientific psychometric properties. Really shouldn't be allowed in. Okay, our court's calibrated. I already told you no. But now I'm going to show you a little bit of the data. We did kind of well, I didn't, but Michael Sachs and law professors did do a deep dive into some actual cases where we know that this type of evidence has come into court. We reread, if we could find them, admissibility challenges, and if we know if there had been an admissibility challenge, what happened ultimately in that case. When we know that there was some type of this evidence across this sample of cases, we found that only about 5% was there any evidence that there was a challenge at all. Only 5% of the cases was there a challenge at all. So this gets to Judge Gertner's point about if the lawyers don't raise the issue, the judge is kind of stuck, right? At least in the structure of the way things are now. When they did raise an issue in those 5%, that narrow band of cases where there was a challenge, the judge often didn't do much with it, right? So in 32% of cases, it succeeded, meaning that there was an admissibility analysis in which the judge decided this is not admissible evidence. And only some of those were on validity, on the issue of validity, which we really cared about. Notably, in a lot of those challenges, the judge said the issue should go to weight rather than admissibility, which is part of what's going on, part of the conversation going on right now with the current rules of evidence changing, so that the language in the current federal rule of evidence is changing to try and get judges to stop doing this. So basically what they're doing when, I think this is my understanding of how things work, that judges say, this is complicated, this evidence, it clearly has some pros, it has some cons, but instead of me making an admissibility determination, I'm gonna say that problem should go to the jury or to the trier of fact. The jury should have to grapple with that and determine what weight that evidence should have in their ultimate decision in this case. So they're passing along the difficulty of dealing with how hard this is onto the trier of fact. So in terms of just the timeline of what's going on with the federal rules of evidence, well, before we get there, this is a quote from the Advisory Committee on Evidence Rules, and they're kind of pointing to what I just showed you in that data, that many courts are holding that these critical questions are questions of weight and not admissibility. So we know this is one of the challenges, one of the problems with this way Daubert is currently set up, and one of the things that it is trying to be fixed, I suppose. So they're arguing it's an incorrect application of the rules, and therefore they're trying to change the rule. Gatekeeping expertise is difficult. I know we're talking about this a lot. I have a lot more I could say on this, but I'm going to kind of skip forward. It's also not just a US problem. So these epistemic challenges, these philosophical differences between systems and asking courts to try and gatekeep scientific evidence, that's a really tall order. And of course, it's not just a US problem, but different countries have evolved different evidence standards and different rules to try and grapple with and reach solutions for how to do this. A lot of common law countries followed our lead after we had our Daubert kind of revolution, but Australia explicitly said they had an evidence legal reform group with a bunch of smart people, smart legal thinkers who said that's not going to work. It's not going to work, and we're not going to do that because it's going to be resource intensive and judges can't do it. So Australia said we're not even going to try. So went there, we had a look at basically just from this very narrow lens of psychological assessment evidence, if they're much less strict rules, if it were a problem, right, compared to us. Are they letting in better evidence? Are they screening out problematic evidence? And basically, we're not done yet, but basically the gist of where we are now with this project is that their approach that has much less intensive rules is basically working about as well as ours seems to be. It doesn't seem to be any better, doesn't seem to be any worse. I think there's a lot of reasons why that might be the case, but it's of interest anyway as we think about what the rule might be, what the standard might be, and how we might try to move forward. What can we do? There's a ton of things we could try to do, some of which have already been tried and don't work so well. I'm not going to talk about this all here, but I'm sure as we go through these next 2 days, people will be talking about things like these. I did mention the Federal Rules of Evidence revision, so I want to just tell you again that timeline of what's happening. After the 2016 PCAST report, which several people have referenced, there was a 2017 symposium at Boston Law School kind of on these issues with probably a lot of the people who were present in this meeting. There was a subcommittee on 702 revision appointed. 702 is the Federal Rule of Evidence that guides the admission of expert evidence. Then in 2021, that committee kind of came out with their proposal for how the rule should change, how Federal Rule of Evidence 702 should change. There was a public comment period. Some of us may have commented on whether what we thought about that. May 2022, the committee approved and sent that report to the Judicial Conference of the United States. In September 2022, the Judicial Conference approved those changes. Then they sent it on to the Supreme Court. April 2023, Supreme Court approved those changes, sent a letter to Congress and the Vice President, who I think the default is it's going to move forward and changes are scheduled to take effect on December 1st, unless Congress or the Vice President steps in. But the default is that these rules are going to go into effect. I have that language. We can look at that if we're interested, but I'm going to stop here. So, thank you.
So good morning, everybody, and thank you for being here, and thanks for inviting me to spend some time talking with you. I'd like to spend a few minutes talking about about scientific evidence and in the courts from the vantage of someone who works within the courts and have worked within the courts for pretty much my whole career, not as a judge, but as someone who in some ways is a helper to the system, doing research to support the system. And looking at the conference agenda and listening to the speakers that have come before me, I think you're going to hear a lot about the role judges, or sort of the tools judges may use to educate themselves, the tools litigants may use to educate judges, sort of what the rules of the court should be, particularly within the context of Rule 702 admissibility determinations. And I'll say a little bit about that too, but I actually wanted to focus on something a little broader. And with apologies, I think I'm going to bring a little bit more tension to the decision, sort of what we're talking about. But the first thing I want to focus on is that I think in the last decade, I think there's been an increasing mismatch in our government between the locus of scientific expertise and the need for it. And so just bear with me. I guess if I were in a court, I'd say, just give me a little latitude and let me explain what I mean. But basically, as most of you probably know, most scientific expertise in the federal government is located in the executive branch, in the agencies. And I mean, I looked at this, and I think in 2020, there were 280,000 scientists or engineers in the executive branch. Now, half of them were in the Department of Defense, but the other half were spread among a lot of different agencies and bringing a lot of scientific expertise to the executive branch decisions. And then clearly we have some coordination on that part. We have the White House Office of Science and Technology and the cabinet level National Science and Technology Council to provide direction. So it's very coordinated and expansive in the executive branch. Okay, so by contrast, if you think about Congress, and I'm not putting Congress down at all, but Congress has two committees. The Senate and House both have two committees, I think, or several committees on science with science oversight, and they of course can request research by agencies and non-governmental organizations. But the congressmen, the members of Congress themselves have remarkably little scientific experience and background. I would give you a count. I actually looked down and looked at resumes, and I think I found about 17 who had that kind of experience. And so what it tells you is they don't bring to their job this grounding as a scientist or an engineer might in the executive branch. And I can talk more about this, but I'm not here to talk about Congress. They don't have a lot of leeway to get routine information about science on a day-to-day basis, but yet they're called upon to make decisions. And then, as we've heard about this morning, we have the courts. And so judges, often equally without science backgrounds, largely rely, as we've heard, on the adversarial process. And so we have briefs and evidence brought to them before the parties, some of whom may be partisan in some ways, or at least part of the advocacy team. And so that's how we get judges to understand the evidence. So I guess what I want to say is, why is this important? And I think it's important because of something that's happening in our country about the rebalancing of where science is located. And that is, the Supreme Court, as many of you who've been following this, have been limiting the decision-making authority of administrative agencies. And that's where the scientific expertise lies. So it leaves more responsibility with Congress to make science-based decisions, and secondarily, more sort of responsibility with the courts. And for those of you who are lawyers, and I won't get into this, but I'm happy to if you want, we can talk about the Chevron doctrine, in which courts have basically given sort of broad interpretation to administrative interpretations of laws, unless they're ambiguous. And then we've seen in the last year sort of the pulling back of that, relying on the major questions doctrine, an environmental case, which basically, I will just say it, it's basically what that case says is that administrative agencies must point to clear congressional authorization when it asserts authority to act on questions of major national significance. So basically we're seeing, there's also another doctrine that the courts, they haven't used since 1935, but in a recent opinion, it looked like they might use it sometime. And that's sort of the doctrine of non-delegation, in which the Congress is not supposed to delegate their legislative authority to other government entities or non-government entities. And so I think what I'm saying is we sort of have a problem here. The scientific expertise is needed more and more where we don't have it. And so I guess Chancellor Mnuchin said, we're asking people to do some very hard things. And I think I'm here today to sort of think about how we help those people do those very hard things. Because when you sort of fundamentally think about science in the courts, I think you have to think outside the 702 context and think about sort of the differing roles we've assigned to different institutions in our government and the rules we're asking them to work under, which goes to your point, Nancy. My second observation sort of builds on the first. When we talk about science in the courts, our attention is often focused on cases in which the admissibility of evidence is challenged. And we've talked a little bit about how it's challenged more often in civil cases than in criminal cases, largely because of some of the characteristics of that litigation. And it's really all good. It's good we're talking. But I think I would make the point that the need for judges to understand science is much more ubiquitous than that. And it transcends Rule 702 situations. It transcends situations in which scientific evidence is brought up in criminal cases even. And this is what I mean. Oftentimes, we all encounter science information in our day-to-day lives. It's really important to understand it. And a perfect example of the federal courts is often they see defendants who have some kind of addiction problem. It clearly would be useful for judges to understand the science of addiction and thinking about that, whether the evidence is presented to them or not. And so I would argue that our sort of task is more than scientific evidence, it's scientific education. And so I guess what I would say is, how do you bring general science to judges? And that's where I'm going to say some good things. I work at the Federal Judicial Center. One of my longtime colleagues is in the audience, Joe Cecil. I remember he was there when I came, and I was there when he left, not too recently ago, but we still talk pretty much every week now because we're working together. But basically, our primary missions are to educate judges and provide education for judges and other court staff, and then to conduct and encourage research on to improve the courts. And I want to say, sort of focus on a couple of things that we do to sort of improve judges' scientific acumen. So basically, we have educational programs for judges, and periodically they cover science issues. I see someone in the audience who was part of, we held a joint, for example, programs on climate science. We've also held recently programs on law and biosciences, law and technology, artificial intelligence, neuroscience, and others. So we build it into our programs. And with the cooperation of AAAS, we've also been building a webpage of really science information. Every year we have a AAAS policy fellow who comes to the FJC, and largely they come with some kind of scientific expertise that's very unique to them, and they'll develop materials for judges that we put on a webpage together. And we've had, I will say that the topics on this page are very wide-ranging, and they're also very limited due to the resources. We have something on fingerprint identification, neuroscience, genomic issues, the science of hydrology, which is actually quite relevant in some of the litigation that's going on today, and the opioid crisis. And pretty much every time a AAAS fellow comes, we add to that page, depending on their particular scientific expertise. So that speaks to the cooperation that we need with the scientific community. But I think we've mentioned several times the reference manual for scientific evidence. And when we talk about the reference manual at the center, it's always talked about sort of as part of a trilogy. And we view it as a hallmark of what we do. We have another manual, the Manual for Complex Civil Litigation. We have the bench book for United States judges. And then sort of right within that trilogy is the reference manual. We talk about them sort of as of equal importance and prominence. And I think the first edition, I think I fairly could say it was the brainchild of Joe Cecil, my colleague in the audience, my former colleague in the audience. But more recently, for the third edition, and then the fourth edition, we've been working with the National Academy of Sciences. And that's brought a really gravitas to the science, and I think the manual's grown in sort of its perception throughout the community. One of the things that's really interesting is to watch the committee that is overseeing and providing direction to the project talk about the topics. It's made up of both scientists and judges. And some of the tensions that we've talked about today just come to play right there, just listening to them to talk about chapters on different kinds of issues. But one of the, I think one of the things I like about the manual, but at its really core, is there's an initial chapter that talks about admissibility of evidence, and then one that talks about science, methods, and sort of the scientific process before we get into the details of different kinds of scientific areas. And I think those two chapters provide a really good grounding. And then I guess I don't want to spend too much more time because I want to leave time for questions, but I think the other way we try to help judges is to help them understand sort of the tools and options they use to understand science. And so we've, tried to give them sort of like considerations if they're going to have, for example, science days in court, to bring in experts with the consent of the parties to sort of help learn about an area of science. What are the considerations? What makes it fair and effective mechanism? So I just want to conclude in just a little bit is I guess there are a lot of sort of private and public institutions similar to the FJC who are trying to do this kind of work. And I think clearly one key to doing it well is for judicial educators to engage with the science community and with researchers like at this conference, sort of to learn more. And I think the other key issue that I think is really hard is we have to face a reality. It's almost impossible to expose judges to every scientific issue they're going to encounter. We just can't do it. There are too many of them. And you don't know what's going to come next. And so I think when I think about this issue, I think it's important to equip judges with a broad understanding of scientific methods, scientific process, how science approaches issues, and teach them how to be good consumers and good critiquers of scientific evidence. Because they can delve into the details with the appropriate tools, but until we give them the tools, it's very difficult. So anyway, in the next couple of days, I hope we get some sort of insights into what we might bring into judicial education programs and also research that might be done on the courts to help. So with that, I'll stop and thank you.
Thank you for those terrific presentations, very thought-provoking. I don't know if people have questions. I'd like to ask about solutions. We seem to want everyone to know more about science, possibly jurors, lawyers, judges. I'm wondering what sorts of things you think would work. Do we need to have, for admission to law school, people to know some area of science or to have it on the bar exam? Should there be scientific courts or panels of experts who can be part of that? And should there be a better certification system for the experts, perhaps by the different professional associations? What sorts of things do you think that we should have? Do you want to start?
Yeah, I want to start because I kept on thinking during your wonderful presentation, Dr. Wiggins, that, I mean, what is the phrase that says you can bring someone to a table but you can't make them eat? And I think that we have now seen that in the years since the 2009 NAS report. I think the issue is not education, although that's important. The issue is what are the incentives to get judges to actually pay attention to this. Another sort of silly story. I was teaching law and neuroscience, which is one of the things that I teach, and with the other MacArthur fellows. And it was a very elaborate presentation about the group to individual inference, very complicated presentation, numbers of judges who chose to go there. One judge raises her hand and she says, you know what? I don't ever pay attention to any of this. I just listen to the evidence, and I think if the guy is credible, I let it in. At which point one of the scientists said, you know, snake oil salesmen were really credible. But the impediment to taking this information is the question. What are the incentives to get judges to absorb this?
I don't know, is this on? No, press it up at the bottom. So one of the reasons that we're going to use all of our time talking about this. But one of the reasons I actually have enjoyed going back and looking at some of the decisions, sort of looking at sort of constriction of Chevron and the emergence of the major questions doctrine and the non-delegation doctrine, is because at its foundation, Chevron talks about where deference to scientific and technical evidence should lie and who has that expertise. And I think that that's one reason I'm interested in it, but the other reason is because it really brings to bear what types of procedures, what types of constraints actors at different, I'm saying organizations, but in different branches of governments feel like they're operating on and under, and are operating under. We have rules of procedure, rules of evidence, but we have in deference to different different government, different branches of government, but that happens within every branch of government, and I think we really need to get at the foundation of that, and that's why, that's part of what I'm interested in that line of cases, not because I'm really, I think where we land in terms of, the balance between the three branches of governments in certain issues isn't as important to me as like what rules we're operating under and what that has to say for how we can bring information into the decision making. If that.
I had a thought too. So I didn't realize that there was disincentive. I learned today, I think from your presentation, that there was disincentive in the criminal system for defendants to bring admissibility objections, which is obviously maybe a structural theft. I mean, there's probably a good reason for that, but that's maybe a bad intersection of different ideals or something, right? So I don't know why, but maybe that's an opportunity. And also there could maybe be new incentives. If this were a solution that maybe could be part of the way forward, then maybe there's a way to create incentive, and maybe part of that is changing the standard or making there some kind of incentive to do appeals that would be successful.
The disincentive comes from the fact that we have a plea bargaining system, and you get rewarded in direct proportion to how quickly you plead guilty. So a lot of issues are left on the cutting room floor to get to a result, and the government sort of prosecutors count on that. So that's a problem.
Hi, thank you so much. My name is Donnie Stedman. I'm the director of the Forensic Anthropology Center at the University of Tennessee. And a lot of what we do is basic research about foundations of, well, we've turned to junk science now. And so, Judge, you'll be happy to know that one of the research projects that I'm doing right now looks at residual odor, whether cadaver dogs and their handlers can detect residual odor. Yeah. No. But but those are things that, yeah, he is not a cadaver dog, just saying. So, but we look and see, what the courts are, where the junk science is coming in. But here's my question. I don't have time to look at all the cases going into courts to be able to before they go into court, before it becomes precedent, to get in front of a judge or send an amicus curiae brief or something like that saying, this is junk science, you need to hold a hearing, or I'm happy to talk to you about this. And I'm thinking specifically about witching rods that got admitted into court in Georgia by a GBI agent to find bodies. There's absolutely no scientific basis to this. There was no pretrial hearing about it, and it's now precedent. And so now we're behind the 8 ball in terms of trying to deal with that. And so my question to the panel is, how as scientists, as just individuals or, directors of groups, how can we get to you? How can we head this off before something becomes precedent? That's my question.
Well, to some degree, what is precedent in a state court in one jurisdiction is not necessarily precedent across the country. So that is a limiting principle with respect to that. But it really goes to a point that I was making, which is the courts. So there's new science and old science, and a court will re-examine new science because they have to. But with respect to old science, that which has been admitted over and over again, what are the incentives to then reevaluate when the science suggests that the underpinnings are wrong? And you'll have that with your case. There's no reason why someone can't come in and say, that decision, the underpinnings of it are ridiculous. There's no reason why someone could do that. But one of the problems which Professor Mnookin was saying and we were saying is that so you have one judge who said A and another judge who said B, gee, that's a great abuse, it means it's within my discretion to do either A or B. And what you need is either a scientific body to say A is wrong, A is wrong, A is wrong, and you need an appellate court to say, okay, A is wrong. Now, as I said, you have seen it with respect to bite marks. That is finally turning around. And you're beginning to...
It's happening, right? It just happened in Australia with Shaken Baby.
Shaken Baby, yeah. And you're beginning to see that. But I think the one theme that we have to add to this discussion about courts, and I can speak to personally, is, a murder case with ballistic evidence that is dispositive. You don't have to have been a judge who was a former prosecutor to understand the stakes of your decision in excluding that. I was a criminal defense lawyer, and I felt the weight of that decision all the time. And it's the same thing with Shaken Baby issues. So the question is, what are the supports, the institutional supports we can provide to judges making this decision? Maybe it's the rules. Maybe it's the Court of Appeals. Maybe it's also a public relations entity that will say the judge did this because. But you have to provide the institutional supports. Otherwise, just saying that it's wrong won't work.
I think, too, and not to add another issue, but I think one of the problems is...
Are we out of time? Can you push a little harder?
Here, take mine.
I was just going to...
Okay. Is it on now?
Yeah.
Okay. So I think one problem that hasn't been
Mine is on.
Okay, so I think, and I'm taking more time to get to my point than my point is worth, but one of the things I'd also like to add to the table is there's some scientific issues that are more settled than other scientific issues, and that makes it hard to change the rules. And I think when you're thinking about the rules, you really have to think about, how do you deal with science that we think is settled and science that's evolving? And sometimes it's just not, sometimes we think it's settled and it's not, as we mentioned earlier. So I think that adds to the tension of how courts can deal with it and how we expect courts to deal with it. I'm going to share.
Hi, Rick Limpert, a retired evidence teacher. I have some observations which I'd like the panel to react to. I thought these are great talks and interesting ideas, but I think the elephants in the room were never mentioned. First of all, most of the forensic science that's introduced in U.S. trials is introduced in state courts, not in the federal court. You have different qualities of judges, different modes of selecting judges. Prosecutors are very likely to become judges in state courts. Judges must run for election or reappointment very often. So at the elephant in the room, I think at the trial level are the biases and the interests of judges apart from the law to convict criminals or not to let people who the public may think are guilty off, plus the close relationships these courtrooms often have with prosecutors. They're part of the same working group. At the appellate level, I think the elephant is somewhat different. And in a sense, it's not all bad. In my experience, appellate judges want to do justice. And that means that if they think a defendant was rightfully convicted below, even if there are errors, they often bend over backwards not to acknowledge the error. Sometimes to make bad law. When they're making the least bad law, they do it by ignoring the issue, by saying we won't address it because if it's error, it's harmless. Or if they address it, they say it's harmless. So even if they find a mistake, the lawyers and the trial judges in the next round know that they really don't have much of an incentive to take seriously the definition of the mistake because the error will be regarded as harmless. So That's outside of the system, and that's the system that your suggestions have to work in. How do you deal with those issues if you agree that my diagnosis has at least something to it?
So the question is, how does this relate to the state courts in contrast?
Well, no, it's not particularly how it relates to state courts, just pointing out that when we have distinguished speakers, as we have here, it almost always happens that the focus and their experience is on the federal system, whereas most of the action is going on at the state level, and we have to deal with it there.
The example I gave of Judge Nance and the Supreme Judicial Court's eyewitness identification task force was a state court task force. And what he thought was eyewitness identification needs to be reexamined. There's no question about it. The science was completely at odds with what was going on in state courts. But judges needed support to do the right thing. It wasn't enough just to say, hey, here's the right thing. So he created a task force in which numbers of stakeholders would be involved. And this then evolved over the course of 3 or 4 years until he... Oh, yeah, here we go. He created a task force because he understood the politics that you are describing with, police officers involved. And that made all the difference in the world. Selection of judges on the state side, there's nothing much we can do. Appellate judges ducking. I have an article in my brain that goes, here are the rights you think you have, but you actually don't. And that is because of harmless error standards, because of good faith standards, all the ways that an appellate court can duck from really coming to grips with a case. That has to be addressed in the law more than anything. But my general point was the consequences for district court judges will not be, opprobrium of their neighbors if they fail to exclude evidence. In fact, just the opposite. The only meaningful consequence is if you change the appellate standards and you make it clear, as opposed to more ambiguous. If people are being reversed for admitting this evidence, that will be a different issue. That has to be a start.
So I'd just like to say that this has been a really wonderful panel. I think that much of what we've talked about does relate to state courts. The National Judicial College has programs for both federal and state judges where they teach about science much as your center does. And for decades, I've taught through the California Center for Judicial Education and Research. So the kinds of programs and ideas we've talked about can help judges in this theme of judges as gatekeepers. And I think that maybe there should be more science taught for new judges. So I do think that the elephant is here. We see the elephant. So I just wanted to defend the panel here. And my high school debate partner just became chief judge of the New York courts, Rowan Wilson. So I think there's some good state judges out there. I'm here to defend the state judges. And so thank you very much for a fantastic panel.